All right. We are back on the record. Mr. George, you're aware you're still under oath? Sir?
Yes.
Okay. Ms. Probst, you're not going to ask any questions? Okay, so for purposes of the record, she's not asking any questions regarding, we're going to limit it to testimony that was just elicited by
Mr. Chair.
counsel.
Yes.
Yep.
So with respect, call attention to the May 30, 2025 order after second pre-hearing conference with additional or revised deadline. Date is May 30.
Hold on, I got a bunch of orders up here.
No, understood.
My fault. Oh. January. Okay, I have it.
May I show the witness?
Well, let's hold on before we go down that road. What's the purpose of showing the witness the order?
Page 2,
Okay.
line, beginning at line 13, fourth bullet point,
Yes.
talks about a deadline for final exchange of witness list and supplement pre-filed witness and expert witness testimony. Date is July 15, 2025.
Okay.
Mr. George, I was reading from the order about the deadline of July 15. It's the side-by-side comparison that you've talked about. Was that concluded for July 15, the one you said that was in late June, early July?
It would have had to have been because we had signed the contract with AutoCAD by then.
And I'm gonna object, this is a legal issue. Something like this much.
I get it.
I'll also say that at his deposition on July 2nd, he used the word superiors. But he already put them on notice.
I get it. I'm gonna overrule the objection and allow the testimony.
And just for the record, you didn't submit a supplemental pre-filed testimony.
No, I did not.
That's it. Thank you.
Mr. Tomlinson?
Nothing.
Okay, Ms. Garrett?
Nothing for me. Thank you.
The director?
Mr. George, you mentioned you've got almost 4,000 cabs across the country in many other markets. Essentially, you have the most exposure to an infringement claim, correct?
Correct.
You mentioned legal defense fund, which you imagine sometime would kick in to address these infringement claims.
Correct.
Is that legal defense fund currently assisting Desert or Captain in this?
No, because no action as far as I know, has been filed.
Is it currently challenging the patent claim?
There is, my knowledge, no. You're asking what I think or what the reason it was being brought against Captain is because of the group of technology companies that could be infringing on it. Captain appears to be the weakest. So if they can get them to capitulate to the statement or to this fee, it provides IVSC the funds then to go after the rest of the industry. Had they gone after one of the larger players, I think they would have found out that there's significant legal resources that would have been deployed against them to let that happen. So they picked the weakest lion in the pride to try and pull it off and then use the people of Las Vegas to grab a fee so they could then build their own legal war chest up to go after everybody else. That's why I'm here opposed to this. If there's a patent claim, file the patent claim. But to not have to go and prove that you have a valid patent that you say infringes and then say the people of Las Vegas and the companies that own these permits that are trying to make a living against all these competitors have to bear that cost. That seems to me to be completely out of whack. And it's unlike anything I've seen in any other jurisdiction I've been involved in 40 years.
I would say using that logic, wouldn't it make sense for some kind of legal defense fund that may have to be formed or grouped in the future, wouldn't it benefit you to do that now so that I can't restate exactly what you said, but you said they're using this to then go after the bigger ones. So wouldn't it make sense to address it now?
Or they just come in and say, we got a $6 million a year annuity coming out of Las Vegas, and we'll sell that off for 40 or $50 million and call it a good day. The concern I have is if you do this, then who's next to come in and say, I have this obscure patent that's going to do it, and we're going to go and get funds there, and it just doesn't stop, and all it does is embolden them. To me, you have a company that says they have a patent, and they said a technology firm infringed on that patent. That doesn't involve any operators or the passengers in Las Vegas. There is an indemnity clause in the contract that I have with Captain that says that they represented to me that they own this technology, there was no problems, and they would indemnify our company if they were found out to have any issues with it. Now, Captain is saying we don't have the resources to do that, which is why I believe they were targeted in this threat. But nobody has come in yet and said, you know, to me, that the expense that really needs to come in is not a legal defense fund. It's a patent firm that wants to come in and say, hey, I can defend this, or maybe you do have a problem here. If that's where the money should be spent, I have no problem with somebody doing that. I don't think it's our battle to fight. I think that's Captain's battle to say, we're going to go and have the resources. And if they want to go to their customers and say, if you want to keep using our technology, it may be a good idea for us to collectively put together $300,000 or $400,000 to hire a patent attorney to give us a professional opinion as to whether or not this is defensible. That to me would be a smart thing to do. But to say that as an industry, we're going to dedicate $6 million a year for what may be a perceived problem on the backs of customers and drivers and owners, that I don't agree with that. I think it's bad policy. I think it's wrong. And that's why I'm opposed to it.
And I understand why you're opposed to it. I'm just trying to figure out what your skin in the game is. Because you said on the one hand, if it goes far enough, you might organize a legal defense fund to protect not only you, I assume, but any of the parties that contribute to operators or tech companies. But you also said they might just take our ruling or in the proposed settlement and sell it for an annuity, which at that point you wouldn't have any exposure.
I can't tell you what their strategy is if this rate case is allowed to go forward, and I still think there's been so many other issues identified with it, who collects the money, how you decide if it's a different provider there, and how complicated all of that gets. Let's assume that in this perfect world they laid out, you can figure all that out. What I have a problem is, you've heard testimony, as I've sat here the past couple of days, you've heard testimony, we're going to use this money to improve our technology. Well, I went out and found somebody else that can meet all the requirements that Clark County requires, and the taxi authority requires, that has much improved technology, in my opinion, for a considerably lower price than what I was paying. So I don't understand why I'm being lumped, or anybody would have to be lumped into that group and saying you're locked into this provider. And it's not as long as we meet the requirements that are there to fulfill our reporting and our duty to the taxi authority, the bells and whistles and features that we think are necessary, that's a private business decision. Where I said that the industry would come together is if they took this, what I look at as a windfall, $6 million a year, if they took that and then got emboldened to say, we're going to go after the rest of the industry, you're going to see a lot of very large international tech players come in and say, we're going to stand together and not let that happen. Had there been a finding by an independent patent attorney or someone that said, yeah, we think, we've looked at this independently and we think there's a problem here, maybe it's time to come and have this. But until that finding, I don't think it's proper to go ahead and just assume that it's valid. And I know nothing about patents. That's not, you want to talk about the cab business? I consider myself an expert in operating cab. I don't know anything about patents, but I do know business. And to me, this doesn't pass a lot of tests before you go ahead and basically levy a $6 million fee, not only to the government, going to a private business. It's mandated by the government. I don't understand it.
But I understand what you're saying. Are you aware that any of the interveners have consulted a patent attorney?
Don't know if I think they've been consulted. I don't think anybody's been retained and actually to dig in and do it. I am aware that one of the interveners, Herb, did talk to their patent counsel because they represented that in meetings and talked to them, and their patent counsel felt that there was no validity to what IDC was saying.
Objection, hearsay.
Probably. I'll sustain it.
Thank you. No more questions.
Yeah, be heard on that last objection.
Sure,
We've been told a couple of times, this is a 233B
it is.
proceeding, follow a little bit and stuff.
Yep.
Putting the rules with regard to hearsay. Okay.
Is a question by a member of the board, and it solicited, there's probably a way to ask that question that doesn't require hearsay though either. Because we could just generally ask him what his understanding is of that decision or that inquiry. But I think he's already testified to it previously. That's why. All right.
I put for the record that I wouldn't have objected, but it's almost a double issue because he's testifying what someone else told him that was told to him by someone else. So.
Yep. And again, we've said all along in this instance that we're not here to make an adjudication of whether there is a valid patent and whether it's enforceable. We're not here to do that. This is a rate case, and that's all that we're here to do. So my ruling as to whether or not that was or was not hearsay and whether or not those questions create that type of relationship also have nothing, not 100% to do with the rate case that we're here to talk
Thank
about.
you.
I think everybody asked the questions, but thank you, sir.
Bill Tomlinson, for the record.
That's fine. You may.
Mr. George, have you retained counsel of your own in this matter?
No.
Whose counsel are you using?
We participated in during Mr. Shear's fees.
Okay, you haven't hired your own attorney. Okay, and you haven't hired any IP attorney, have you? All through your testimony, you kept saying, bring the industry together. People are going to group and I'm going to set this thing up and I'm going to save the industry. But yet, what have you done to actually do anything to investigate any of the claims in this case?
Talk to the companies that provided me the software that have indemnity agreements and asked them to review that to see if they have any exposure on their end, and they've assured me they do not. That's the extent that I felt that I needed to go as a business. I have an indemnity agreement. I have the assurance from the company that they don't infringe on the patents. I don't feel I need to go any further than that. If somebody wanted to target us in litigation, then at that point, I would take steps to aggressively defend it and go after it.
So I believe in response to Member Decker's question, you would say that you would recommend someone pay up $300,000 to hire an IP lawyer to at least investigate the claims.
I think Captain would have done that.
You don't think they have?
Seen the report. I haven't seen Captain come to us and say that we believe we're infringing and we have to change something, or we're going to indemnify you based on this. No, Captain's not said a word to me about what they're going to do on the indemnification.
You've been here the last couple of days, right?
I've been here.
So did you hear the testimony where they testified that they have two separate IP firms that they've retained?
What I haven't seen is the Captain has my former vendor coming to me saying that we feel you have some exposure and we have an indemnity agreement and here's what we're going to do to protect that. I haven't seen that. So as far as I'm concerned, if you're asking me as a business, do I have any exposure? My answer is no.
So if hypothetically, if this application is not granted and IBSC chooses, they could choose who to sue in the stream of commerce. They could sue you, they could sue the technology providers. So let's assume that they would sue you. So at that point, then you would do this analysis?
No, I would.
Hold on a second. I think your attorney has an objection, Mr.
Objection. States legal theories that have not been established, and is asking him for a legal opinion and speculate.
I take it as a hypothetical to a lay witness, and that if he thinks he understands the question, he can respond and answer.
It's a business question. It wasn't
Yeah.
hypothetical.
So I'm going to overrule the objection.
I'm in a business that is target of litigation all the time, and we have strategies in place to defend ourselves aggressively. And if we feel that it's been selectively done, then we would go back and aggressively do that and defend it. So
So the bottom line is, until you get sued, you're doing nothing. Is that basically your testimony?
you need to explain it until I
Until
get sued
until your company gets sued for willful infringement, you're not going to do anything.
from the end of January till we got off the system in July. You're right.
More questions?
Please tell me.
One question. Yeah,
Yeah,
no, it's on there.
All right.
Think further.
Okay. You're excused. Me. And just to clarify, none of the witnesses have been subpoenaed for here today, correct? I want each counsel to say yes.
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 That's on the. Mr. Shearer, your other witness, please.
Jonathan Schwartz.
Yeah, I'm waiting for. Yep, you're good. You're good. You ready? Okay. Swear the witness.
Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Mr. Schwartz, please state your name for the record.
A. Jonathan Schwartz.
And I would direct you to Exhibit 38 in the
Vice Chairman, objection. Thought we were still going through the same program.
We are. I'm assuming he's just teeing up the exhibit. Mr. Shearer's done it a little different. I got it. I think he's just teeing up the exhibit.
Right.
Okay. Yeah. We got it.
Do you recognize this document?
I do.
And is this your pre-filed testimony in this particular matter?
It is.
Okay.
And there's no supplement.
There's no supplemental.
Okay. Got it. Well,
Oh, sorry.
yep. You may be first, who knows, but this, are you gonna go or?
Good afternoon, Mr. Schwartz.
Hi.
Pui Premstert on behalf of Desert Cab. Just a few questions. You, on behalf of taxi management, you've asserted that the second amended application was not properly noticed.
That's a legal question. You gotta ask the attorney.
Well, regardless of the legal issues, you were aware of the 12.5 cents when you sat for your deposition.
I was not.
You were made aware at a minimum of the 12.5 cents as of August 15th, 2025.
I don't know when I became aware of it at some point.
And you've had the ability to not only file pre-file testimony, but an opportunity to file supplemental testimony, correct? So despite any objections, legal or non-legal, you've had a full and meaningful opportunity to be heard.
That's illegal.
You're not a patent attorney. And you testified during your deposition that you have not conducted your own review of IBSC's patents, correct?
I have not.
So when you testified that Captain's technology does not infringe, that is just your personal belief and not an expert legal opinion, correct?
It's based upon my discussions with other people in the industry.
But again, you did not engage a patent attorney and your opinion is not in reliance on any counsel. You testified that the 50-cent fee burdens passengers. Do you agree that passengers would be harmed if more taxi service collapsed due to patent litigation? And you believe that because there's an indemnification agreement from Captain, correct?
There's numerous reasons. That's one.
Well, let's talk about indemnity. Under your contract with Captain, Captain has agreed to indemnify taxi management, your company, against patent infringement claims, correct?
That's my understanding.
And indemnity means that Captain is presumably to advance legal costs in the event IBSC sues, correct? But indemnity wouldn't prevent you or taxi management from being named in a lawsuit. Isn't that true?
True.
And your company would still be forced to hire lawyers in that case?
I don't know that we'd be forced. We might be looking upon Captain to provide counsel that we approved.
Okay. But if Captain lacked that money to cover those costs, your company would have to hire lawyers, respond to discovery, sit through depositions.
Probably.
So even if Captain promises to advance those fees, it's contingent upon Captain's ability to do so, correct? And you were present yesterday and you listened to the testimony of Mr. Myers and Mr. Bell, correct?
I did.
And you heard remarks that Captain did not have the wherewithal to pay these fees and costs and to cover all of this in the event IBSC were to make good on its threats. Did you hear that?
Yesterday's testimony.
So to be clear, indemnification might shift the financial responsibility on paper, but wouldn't stop you from being sued as an operator.
Objection.
I'm going to over.
Thank you.
And he answered. Solorio? Yep. Well, we're going in the same order, so you're waiving this round.
Waiving this.
Understood. I just don't want to create anarchy.
For the record, again, Neil Tomlinson on behalf of IBSC IP LLC. Afternoon, Mr. Schwartz. Just to follow up on, start with, Ms. Premsrud just asked you about the indemnity. Hasn't Captain essentially offered you indemnity through their assistance in trying to support this application to have a pass-through fee?
Objection also.
Sustained.
George, you have a law degree, right?
Yes.
Cavalier Foundation, you got to ask him the next question too.
You've been in business since you were 18 years old, right?
True.
You've dealt with hundreds of indemnity clauses, haven't you?
I don't know if it's hundreds, but few.
Okay. As part of your job at Taxi Management or YCS or whatever entity that you're an officer of, you look at indemnity clauses. And in fact, you've looked at it in this case extensively, right? Okay. You feel like you could answer a question about an indemnity provision?
A broad one. I'm not as, specifically an expert in indemnity provisions, but I've certainly read them in contracts when I negotiate them.
Let me state a question this way. Through this proceeding, hasn't there been something that would allow the alleged infringement claims to go away at no cost to you and your company?
I believe that's a mischaracterization of what would occur by assessing a 50-cent fee to the customer that they shouldn't have to pay.
Customers really have a choice on a $3 credit card fee?
Of course they do. They can pay cash. They can elect not to do it.
How often does that happen?
Quite a lot.
So business travelers that you're picking up at the airport, they reach in their pocket and they pull out cash for you? Okay. So do you feel that you've been offered any indemnity by the meeting that was had, that you testified that you've been in attendance of the fall meeting, fall 2024, that this would be a process where everybody would get protected, everybody would have a license, and everybody would be whole because there would be no charge to you?
No, I think Captain capitulated because their board didn't want to spend the money to have a fight over the validity of these patents. That's what I think happened.
But you didn't want to spend the money either because you haven't, right?
I have an indemnity.
You haven't hired an
It's
IP
their
lawyer.
duty, not mine.
You haven't hired an IP lawyer, right?
Not yet.
Okay. Why is that?
Because I haven't had to yet, and I'm relying upon their indemnity at this point. And if the time comes where we have to litigate these patents, I'm sure we'll get a fund together with the industry, with technology providers. It's not simply on me, and it will become right when it does, and it's not yet.
So like Mr. George, are you waiting, sitting around waiting and hoping that you're not going to be sued?
I'm addressing matters as they come to me one by one, and this is how I'm addressing this matter so far.
Well, I mean, isn't it akin to putting your head in the sand?
No,
Yeah, what is the statement? You can ask it a different way.
Mr. Swartz, you attended the meeting that's been discussed over the last 2 days, the fall 2024 meeting of operators, correct? And Captain was in attendance
yes,
and Desert Cab.
yes.
Was Kimberly Rushton there?
Kimberly was there.
And was Mr. George there?
No.
Was he at other meetings where it was discussed?
I don't believe so.
Who else was there?
And
So we've been talking about two different meetings, so let's make sure that we're specific as to which one we're talking about.
Okay,
I have a clear recollection of the first meeting, to
Okay.
be frank, and
let's talk about the first meeting.
And that's the October 31st meeting.
it was early in the fall. I don't remember the specific date.
All right.
I thought I was going to a LOA meeting, quite to be frank. I got there, it was in Desert's conference room on the second level, and Kimberly was there, Brent was there, Brent Bell, JJ Bell was there, Andrew Myers was there. Kimberly Rushton was there. And that's all I can remember off the top of my head. And that's when they, first brought up this issue of these claims from IBSC and Mark James.
So you've been on notice of those claims since then.
I've been on notice that a claim was made against Captain, yes.
Okay. Is Kimberly Rushton representing you in any capacity here?
Kimberly Rushton, I think the official title is Executive Director of the LOA. She's not a patent attorney.
She's been sitting with you during these proceedings, right?
She was here a bit at one point.
So my question is she representing you in any capacity?
Not for this matter, no.
Is the LOA acting at your behest in any capacity relating to this matter?
No, because Kimberly has a conflict because the members of the LOA are myself, uh, Bill George, and George Balaban. And since George has a contrary position, he couldn't really be involved.
So she's not giving you advice as you're sitting back there?
No,
She's not giving you advice in the hallway?
nope.
No. Has she contacted the tax cab authority staff about this case?
Don't know.
Has she contacted any board member about this case?
Don't know.
Have you directed her to?
No.
We try to ask the indemnity question a little bit different now. Would you agree that Captain, well, let me just ask you. You're aware from meeting with them, they did some due diligence on the patent infringement issue, correct?
They told me they did, yes.
Okay.
And I spoke to their attorney.
And did they explain to you that they saw it as an industry-wide issue?
They didn't describe it in those words.
Okay. Did they, at that meeting or subsequent meetings, did they propose to you a solution, what they saw as a problem, which was these infringement claims?
They never proposed a solution to me. They said, I think we should work out a deal with him, meaning Mark James, but nobody ever told me what the deal was.
And to this day, you're still using Captain's technology systems in some of your cabs, correct? Or all of them?
Correct.
All of them?
We are, yes.
Have you heard the term willful infringement?
I'm not a patent attorney. I'm not going to comment on questions of, yeah.
So you've heard of it. Do you recall attending both NTA meetings that were agendized for technology that had been developed by formerly FTI and now called IVSC?
I almost never attend NTA meetings. I think I've been to maybe 2 in my life because they don't regulate the taxi industry here in Clark County. I do periodically attend TA meetings.
Yeah, do you remember specifically attending meetings where IVSC's technology was on the agenda?
Do I recall it? I don't. I may have. I just don't recall it.
So if the minutes say you were there and said words that,
Then I was probably there.
okay, I'd like the board to take judicial notice of the minutes of the taxi cab authority. And I'll have to put in a brief exactly dates. Just to verify.
Clarification, he asked him about the ground transportation authority.
I asked both.
He did, he asked both. And I think the minutes of PA's meetings, we can take notice of. But you're gonna have to direct us to which ones you're talking about and tell us why it wasn't produced as an exhibit in the case.
Well, they were identified as a group.
Okay,
They were identified as potential exhibits, but
in your opening brief?
in, I'm not sure, but it was definitely on the witness and exhibit
On
list.
your exhibit list?
For the record, Jessica Kara from the Attorney General's office. I will say that I referenced some of the meeting minutes in at least my opening brief, but I also cited to the website and the minutes as like kind of like a legislative record more towards the board. And it,
Yeah.
caveat, it was also.
Understood. So everybody's gonna have the opportunity to discuss the documents that they stated on their witness and exhibit lists and go from there. But make sure we've got dates if you want us to look at something specifically that's not attached.
I will. I may have to submit it tomorrow, but I will.
Can I trouble anyone for a bottle of water?
Oh, yeah.
That's sitting on the floor. So much. Fire away, Neil.
Let's talk about, Breeze Transportation Infrastructure was the predecessor name of the company that is now IBSC. You recall going to a meeting at FTI sometime in 2015.
Objection. Way beyond the scope of his.
The scope of his,
Written
Brett's testimony.
Well, I'll direct you to page 67 of your deposition where we discussed it.
What?
I'm gonna overrule it. Tell me which page you're talking about, and what testimony. you're
Page 67 of
So
Mr.
it's in the-
Schwartz's deposition.
It's in the, what is this, mauve? What's this color?
It's
Salmon,
orange to me.
in the salmon book? And you're towards the back, sir.
It's in the book, everyone. You could have them stand in.
Exhibit 52.
Oh, yep. What page were you referencing?
Page 67. Line 3. Through 21. Read that in
I'm
the
sorry,
record.
what were those line numbers?
Line 3 to 21, page 67. Could you please read that to the record?
Well, I thought you were asking him whether or not he recalls going to a meeting at FBI. Did I mishear that?
Well, I wanted to refresh his recollection by looking at what he testified to.
You know, I don't even have to refresh my recollection. I remember what you're talking about.
Okay.
Ask the question.
Okay, so you went to FTI on Decatur, correct?
I went to a meeting on Decatur where this is my vague recollection. Something being presented by Mark James was being presented. That's as much as I remember.
And it was software product, right?
It was something. It's a long time ago, Neil. I don't remember what it was exactly.
It had to do with transportation technology, right?
Something. I walked into the meeting, I watched what they had to show, and I walked out of the meeting. That's about as much as I remember.
Fair enough. You were on notice of them creating technology as far back as 2015, at least.
I can't even remember what happened. I have zero recollection other than going to the meeting and in my developer mind thinking, why is this company in what used to be the bank's office? That's all I remember.
Well, you remembered it was on Decatur. You remembered it was a bank building. So
That's what I remember. But, you know, I'm a developer, so I'm looking at buildings all the time. That's where my head is most of the time.
going back to the first meeting that you testified to earlier with the members of the LOA that you thought was an LOA meeting.
Mm-hmm.
Do you remember specifically any conversations that happened at that meeting?
I do.
Can you summarize them for me?
I remember Andrew Myers saying that he went to his board to get authorization to challenge these patents, and they would not give him authorization to do so. I remember whether it was, I believe it was Andrew who was talking primarily, saying that he had the patents reviewed by Mr. Yorio and by another law firm, and that they had come back with the opinion that it was a concern as to whether they were valid or not. And I said, do you have any memos, any briefs, anything that you can give me that I can rely upon? Andrew told me that he thought I should speak to Mr. Yorio. Mr. Yorio and I spoke, I think, twice. I asked for any memos or briefs that I could rely upon. They sent me something, basically it was the same thing that Andrew provided in the meeting, which was just, you know, a deck for his presentation. Mostly it was just discussion with me and Mr. Yorio about, you know, what the chances were of success in challenging these claims, what it would cost to challenge the claims. I remember some discussion amongst the participants at the meeting and I can't remember who said it, that this was a money grab by IBSC. I remember some people saying, with some comments that I don't want to repeat, with some colorful language about the nature of these claims. That's what I recall.
What was Amos Tamam at that meeting?
Was not. Was not.
And since that meeting, you haven't retained IP counsel, correct?
I haven't. I've spoken with Amos, who retained his own IP counsel to review the matters. I had at least 3, I would call them preliminary meetings with a law firm out of Los Angeles. I had a meeting, a telephonic meeting with an IP law firm out of Denver. We brought in another IP law firm that had a preliminary meeting with us here in Las Vegas, whose name I don't recall. We didn't hire them. I mean, we've looked into the matter quite a bit, but short of hiring our own IP counsel.
Yeah, so let's be fair about that, though. So you had some free initial consultations, but you never retained IP counsel, correct?
Ms. Garrett?
Good afternoon, Mr. Shorts. I don't know if you remember me, but to see you too. My name is Jessica, and I want to kind of ask you some questions about some of the testimony that was given today from other folks. Before I get into that, have you been present for the testimony that occurred this morning? And in case I do reference testimony from yesterday, were you also present yesterday? So this morning, during the testimony from Mr. Bell, he stated that Captain's, I believe it's master service agreement with their clients, has a provision that allows them to negotiate on your behalf. Do you recall that testimony? Is that accurate?
I think it's arguable. I vaguely recall the sentence in the agreement that he's relying upon.
If you have the agreement in front of you, are you able to, it's not in that binder because that's the public binder. It's, I believe, one of the confidential exhibits.
You'd have to point it to
Can you grab one? Thank you.
Small out of trees.
What's the exhibit number?
It is exhibit, I believe 14, but before we go any further, I believe a point was brought up to me by the hearing master about whether or not it can be for review with this witness. If the board is inclined to keep it entirely confidential, I'm going to make a request similar to that I make in III cases, where we could go off record to review the document and then go back on record, do a quick review and then proceed. I don't intend to go in depth with it. I just want it in front of him in case he needs to reference it.
So this is a captain, I'm assuming a captain document.
It is, exhibit 14.
And you're still asserting the confidentiality of it?
We are. But council's suggestion is acceptable to us. We want to defend.
And if that's the case, you may have, and if that's the case, board members, you may have to ask the gallery to leave as well.
We have to ask the gallery and we have to turn off the internet connection.
Going off, right? They can mute it.
Yeah, we can mute it. Sounds like. Well, hold on. Let me hear the parties and if they've got any opinion on this. Mr. Sure.
Provided that.
I'm gonna, Chairman Reeser said that we're gonna respect the confidentiality. I'm gonna respect it all the way in terms of the procedures that we would use. So I think staff can stay in the room. I think we have to turn off the audio feed and still be in compliance. Mr. Feely?
Yes.
Okay. And we'll ask all non-parties to leave. Okay, so council table, I know who everybody is. Everybody else, like, everybody else that's still in the gallery, we need to identify you for purposes of the record.
Carolyn, ED engineer, okay. And Lars, CEO, okay.
Jim Bell, Jim Wood. Michael Bale, General Manager, Taxi Management.
Michael, I didn't hear your last name. I'm sorry. Michael.
Michael Balin, BAILIN.
Deputy Attorney General Ryan Sumner for the taxi cab authority.
Lona Webb, attorney for the Jackson County.
Okay. Any objection by captain to those parties staying present?
No.
Okay. And you're aware that they're gonna, the AG is gonna ask questions of Mr. Schwartz, right? But regarding the document. Okay,
Go ahead, mute.
You,
yes, move.
Do you want the video off as well?